Parliament chapter until Lok Sabha Deputy Speaker. Now we'll try and complete the rest of the Parliament chapter. So next is the panel of chairpersons of Lok Sabha. So panel of chairpersons, generally there's a maximum of 10. They are nominated by the speaker. Okay, that's an important difference. The nomination of a panel of chairpersons is done by a speaker and not by the president. And the speaker nominates them from amongst the membership of the Lok Sabha. So amongst the Lok Sabha, speaker will choose 10 people and they'll become the panel of chairpersons. What is the role of panel of chairpersons? In case the speaker and deputy speaker are not available, they are like either ill or they are on vacation, something of that sort. Then they will have responsibility to the house. They will preside over the office of speaker and deputy speaker from amongst the 10 of them. Another, again, same as deputy speaker, they are not subordinate to the speaker or deputy speaker. They are accountable. They are accountable to the house collectively and not to the speaker or deputy speaker. One important fact here is that they will only preside over the house when there is an absence, as opposed to when there is vacancy. What is the difference? Absence meaning the elected member is there as speaker and deputy speaker. Member is elected as speaker and deputy speaker, and that member is not able to attend the Lok Sabha. That is known as absence. What is vacancy? Vacancy meaning no one has been elected to that post, or the person who was elected to that post has passed away. Okay. In case there is death, then it is vacancy. In case the person is unable to attend due to some other reason, that is known as absence. Council of chairpersons can only preside in case of absence, not in case of vacancy. Okay, that's a very important distinction. Next is Speaker Pro Tem. Speaker Pro Tem is appointed by the President. Like the Speaker, Speaker Pro Tem is also appointed by the President. Usually, senior most person is selected. Senior most person of the members. He has all the powers of the Speaker. His oath is administered by the President himself. Same as Speaker. And unlike the conventions of whip, leader of opposition, leader of the house, unlike all of these, Speaker Pro Tem is mentioned in the Constitution. Speaker Pro Tem, that post, that position is mentioned in the Constitution itself. And this is also a temporary office. Why is it temporary? Because once the Speaker is elected, the Speaker Pro Tem no longer has power. It is a temporary office. So what is the origin of these offices? How do you trace the origin of these offices? Because this is also has been asked as question. Like, where did Speaker, in which act did the Speaker first originate? Idea of Speaker. So Speaker, Deputy Speaker came into existence in the Government of India Act 1990. It is not an innovation as such by the Constitution. Speaker post came into existence in Government of India Act 1990. And initially, in 1919, they were known as President and Deputy President of the House. In Government of India Act 1935, they were renamed as Speaker and Deputy Speaker. 1935, they were renamed as Speaker and Deputy Speaker. So next, what are the powers of the Speaker? This is again important. What are the powers that the Speaker has? First is that you need to know the source of the powers. What are the sources of the power for the Speaker? You have Constitution, you have Parliamentary Convention, rules of procedure of the House. All of them are the source of power. It is not only what is written down. Even convention, meaning custom, tradition, even those are a source of power for the Speaker. The Speaker is also the guardian of powers and privileges of the members. You must have heard about the idea of parliamentary privileges. Parliamentary privileges, all members of parliament are guaranteed certain privileges like right to freedom of speech, like protection from arrest for things that they've said in the assembly. All of that, they have powers. Now, the guardian of those powers and privileges is the speaker. In fact, there is no single law. There is no single law which defines the powers and privileges of the members. There is no single law. The speaker is the one who is responsible. Speaker is the one who is responsible for interpreting the power and privileges. Speaker presides over joint session. This you are all aware. Speaker also maintains the order in the house. Speaker is responsible for conducting the sessions. He is responsible for bringing to order the various bills, passing the bills. Okay, the procedure to be established in the house, that also speaker is the one who does it. His decision to classify a bill as a money bill is final. To classify a bill as a money bill is final. And another small fact which can be important for the exam is that on the request of the leader of the house, speaker can allow a secret sitting of the house. On the request of the leader of the house, speaker can allow a secret setting of the house. Meaning the press will not be able to cover this session. Minutes of the session will not be published. But for speaker to make such a decision, leader of the house has to request. Only the leader of the house can request for secret sitting. If it is accepted, that can only be done by the speaker himself. Now, if the PM is a member of Lok Sabha, then leader of the house is the PM. There is also a request to cover Ministry of Cooperation under current affairs. Let's do that on Saturday. On Saturday, we'll cover current affairs. We'll do Ministry of Cooperation. Now, let's look at the Rajya Sabha equivalent of speaker. Rajya Sabha equivalent of speaker is vice president, also known as chairman or chairperson of the house. Rajya Sabha equivalent of speaker is the chairman, also known as vice president of the house. Then you have deputy chairman. Deputy chairman is elected the same way as deputy speaker. Same process, same grounds of removal, everything the same. Panel of vice chairpersons is also the same. Important thing here is that it is called panel of vice chairpersons. It's called panel of vice chairpersons. In Lok Sabha, it is called panel of chairpersons. So in Rajya Sabha, you have panel of vice chairpersons, again nominated by the chairman. Same process. But again, important difference between Lok Sabha and Rajya Sabha. Rajya Sabha does not have speaker pro tem. Rajya Sabha does not have speaker pro tem. Why? Because Rajya Sabha is a permanent house. Rajya Sabha is not dissolved. Rajya Sabha has tenure. So always there is one vice president. Right? There's either a vice president, or if in the vice president's absence, there is a deputy chairperson. But there is no absence as such, which is why on election, and it's a permanent house, which is why there is no speaker pro tem. And others are generally similar as speaker and deputy speaker. They will also conduct the order in the house. They will make sure that bills are brought on time, procedure is followed, privileges are maintained. All of that is also done by the Rajya Sabha chairperson and deputy chairperson. So next, what are some technical terms within the sessions of Parliament? Some terms which can be important for the exam. So generally, first you need to know that Parliament in India generally has 3 sessions: budget session, monsoon session, and winter session. Between each session, the House is said to be in recess. And in the Constitution itself, it says that maximum gap between 2 sessions shall not exceed 6 months. In the Constitution, it says that maximum gap between 2 sessions shall not exceed 6 months. 6 months shall be the maximum gap. Who does the summoning of the Rajya Sabha, Lok Sabha? It is the president. President is the one who does the summoning. But what about if someone asks you the equivalent in the state? Is it the governor's discretionary power to summon the legislative assembly? Is it the governor's discretionary power to summon the legislative assembly? This fact is very important because in Rajasthan, the Supreme Court gave a verdict about this just in the last year. From current affairs point of view, this fact is very important. Even in West Bengal, even regarding West Bengal, the case has gone to Supreme Court. Is it the governor's discretionary power? Same way how president has power to summon, is it the governor's discretionary power to summon the legislative assembly? Answer is no. Answer is no, and this has been established in a court case. Okay. Next is the term adjournment. What does adjournment mean? And generally, there is a lot of confusion about the differences between adjournment, adjournment sine die, and prorogation. So let's look at these three terms. Adjournment means for the work on a particular day has been suspended for a specified time. So you can adjourn for a few hours, you can adjourn for a few days, you can adjourn for a few weeks. And this adjournment is done by the presiding officer. So speaker, chairman, these are the officers who can adjourn the session, adjourn the meeting, okay, adjourn the sitting for the day. So what does adjourn? What is specific about adjournment? That adjournment will always have a time. It will say we adjourn until Monday morning 9 a.m. We adjourn until Friday afternoon 2 p.m. Adjournment will specify a time. So for a specified period of time, they will the Lok Sabha or the Rajya Sabha will be suspended. The work will be suspended. That is known as adjournment. What is adjournment sine die? Adjournment sine die is when the sitting of parliament is suspended for an indefinite period by the presiding officer. Indefinite period. When adjournment sine die is, we are suspended till further notice. No time is mentioned. In adjournment sine die, no time is mentioned. You are just suspended for an indefinite period. Generally, when does adjournment sine die happen? It happens towards the end of the session. Towards the end of the session, meaning monsoon session, budget session, or winter session, towards the end of the session, what will happen is, they will say this house is adjourned sine die, meaning that it is suspended indefinitely. Then last is prorogation. Prorogation is the termination of a sitting and a session of the house. Meaning when prorogation happens, it is said that the session has ended. Session has definitively ended. What is the difference between adjournment and prorogation? First big difference is adjournment sine die is done by the speaker. Prorogation is done by the president. So in adjournment sine die, the speaker says that until further notice, the sitting is suspended. What happens in prorogation? In prorogation, the president says sitting is ended. Sitting has ended. It is terminated. So differences between suspension and termination. Suspension means it is within the speaker's power to bring out a new meeting. Okay, but once it is terminated after prorogation, only the president can summon a new session. So prorogation is a final step. Adjournment is a middle step. Adjournment sine die is a middle step. So first adjournment will happen during the session. Towards the end of the session, speaker will do adjournment sine die, and final step to terminate the entire session is known as prorogation. These are the three steps, three stages. So prorogation terminates the sitting, and the session itself will get terminated by the president. And what will happen? What is the difference between adjournment? Another difference between adjournment sine die and prorogation. In adjournment sine die, the pending notices and pending bills will not get lapsed in adjournment sine die. In prorogation, if there is any pending matter, or pending notice, that will get suspended, that will get removed, that will lapse. So prorogation basically says that it is ended, it is completely ended. The session has ended. If there are pending notices, okay, in prorogation, they will get lapsed. In adjournment sine die, they will not get lapsed. Next term regarding the parliament is quorum. 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 Quorum is minimum number of members that are needed for the house matters to proceed. Meaning at least, supposing you have 545 members, 543 members in Lok Sabha. If only 5 members are attending, there's no point of holding the Lok Sabha. So you have a minimum number. Minimum number of members need to be present for Lok Sabha to transact business. This is defined as 1/10 of the total number. 1/10. So in 543 members, you need at least 55 members for the quorum to be achieved and meeting to take place. Now, important fact for prelims, is the presiding officer, is the speaker included in the quorum? And answer is yes. Speaker is also included in the quorum. So you need to count the speaker as well as towards the quorum. Next is lame duck session. Lame duck session is the last session of the Lok Sabha. After a new Lok Sabha, like supposing in 2014, elections were there, the last session of the Lok Sabha, after the new Lok Sabha has already been elected, is known as the lame duck session, because the Lok Sabha does not have too many powers, because the next Lok Sabha is the one which has the people's mandate. Quorum for Rajya Sabha is also 10%. 10% of the house. Next is the term dissolution. Dissolution is done after the 5-year term is complete or when there is a no confidence motion. Dissolution is when what happens in dissolution is that the Lok Sabha itself is dissolved and fresh elections should be conducted. So after adjournment, after prorogation, after adjournment sine die, fresh elections are not conducted. But after dissolution, when the Lok Sabha is dissolved, then there is a fresh election. And when does dissolution happen? Dissolution happens after 5-year term is complete or when there is a no confidence motion. And Rajya Sabha is never dissolved because it's a permanent house. So this is done by the president. And yes, vice president is included in the quorum of Rajya Sabha. Next, on dissolution of Lok Sabha, what happens to the bills pending in the Lok Sabha? When Lok Sabha is dissolved, what happens to the bills pending in Lok Sabha? So for this, my trick that I use is that if there is any involvement of the Lok Sabha needed or Lok Sabha was previously involved, in that case, the bill will lapse. So there are different cases you need to remember for whether a bill will lapse or not. Supposing a bill originated in Rajya Sabha and Lok Sabha has had no involvement with the bill at all, the bill will not lapse. What is the logic behind the lapse of a bill? The logic is that if the current Lok Sabha has been involved in the bill, but has already been dissolved, we are going to have a fresh Lok Sabha. So the bill should be passed by the fresh Lok Sabha, not by the old Lok Sabha. So that is why certain bills will lapse on the dissolution of the Lok Sabha. Now, what are these bills? If it is by Rajya Sabha, if Rajya Sabha is the origin of the bill and the bill is still within Rajya Sabha, then there will be no lapse. Why? Because Lok Sabha has had no involvement. But suppose the bill originated in Lok Sabha, or suppose the bill originated in Rajya Sabha, but Lok Sabha has also passed the bill, or the bill is being debated in front of the Lok Sabha. In that case also it will get lapsed. Okay. But what are the cases when there is no lapse? First is that like when the bill originates in Rajya Sabha. Other cases, if the bill is pending the assent of the president. Lok Sabha has passed it, Rajya Sabha has passed it. Now only president's signature is required. In that case also bill will not lapse. Next, if the bill has been sent back by the president for reconsideration by the president, that also will not lapse. And lastly, like just to recall, if there is a bill which has originated in Lok Sabha, if it is present in Lok Sabha, okay, then those will all lapse. Basically, if there is Lok Sabha involvement, current involvement of Lok Sabha, if it is there, the bill will lapse. But if the bill has already gone to the president, it will not lapse. If the bill is still only with the Rajya Sabha, this will not lapse. So this you have to just memorize. Okay, this is there in Lakshmikant. This is there in the note in Lakshmikant. You just have to read it and keep reading. Six conditions are there. 6 criteria, you have to read it and you will remember. Next up, what are some of the devices in parliamentary proceedings? So first is question hour. Question hour is the first hour of every parliamentary sitting. In parliamentary sitting, both Lok Sabha and Rajya Sabha. In both Lok Sabha and Rajya Sabha, first hour of every parliamentary sitting is known as question hour. Now, what happens in question hour? The members of parliament will ask questions to the government, and government is supposed to give responses. What are the types of questions in question hour? First is a starred question. In a starred question, you will have an oral answer with supplementary questions as well. So in starred question, if a member of parliament is asking a starred question, he will get an oral response from the concerned minister. Okay. And the member of parliament is allowed to ask supplementary questions. He can ask more questions to the member of parliament to keep him in check. Next is unstarred question. What happens in unstarred question? In unstarred question, you have written answer. You have written answer and no supplementary questions are allowed. So member of parliament will ask a question. The ministry will submit a written response to the parliament. But member cannot ask any further questions. This is unstarred question. And lastly is short notice questions. Short notice questions are generally, you give notice of less than 10 days. Notice of less than 10 days is given for the minister to answer the question. And the answer for this is also given orally. Because again, it is an oral answer, the members are allowed to ask supplementary questions. One important fact, one neglected fact for prelims is in a private member bill, are questions allowed? Can questions only be asked to the government and to the ministries, or can questions also be asked to private members? Okay. Answer is yes. Questions can also be asked to private members. What are the questions that are directed towards private members? To private members, questions are given based on private member bills that they might have introduced. So question hour is not only for the government officials and for ministers, it is also for private members. Who all is a private member? Any member who is not a minister is a private member. Ruling party, opposition party, nominated member, anything. Anyone other than a minister is known as a private member. Anyone who is not a minister is known as a private member. Next is 0 hour. 0 hour. 0 hour is an informal device. That's the main aspect of 0 hour. It's an informal device and it is not mentioned in the rules of procedure. 0 hour is an informal device of parliament. It is not mentioned in the rules of procedure. So there is no defined period also. There is no defined duration of 0 hour. We say 0 hour, but it is not like it lasts for 1 hour. It can last for any amount of time. So when does 0 hour start and when does 0 hour end? 0 hour starts exactly after the end of question hour. 0 hour starts exactly after the end of question hour, and 0 hour lasts until the agenda for the day is taken up. Until the agenda of the day is started, 0 hour will last from the end of question hour until the agenda of the day is taken up. Okay. What is the specialty of 0 hour? In 0 hour, no prior notice is required to raise issues. You see, in question hour, you need at least 10 days notice for start questions. For short notice questions, less than 10 days notice, but notice you still have to give. In 0 hour, to raise issues of importance, you need no notice. No prior notice is needed in 0 hour. Also, 0 hour is an Indian innovation. 0 hour is something that was started by India. Okay. Next is, what are the types of motions? What are the types of motions? So any matter, if you want to take up any matter in parliament, you need to frame it as a motion. Okay, basically, like similar to how supposing you want to take a matter in a court. Okay, in a court also has procedure. Court meaning you need to file a case. Case, you need to file affidavit. You need to file certain documents in a prescribed manner. You need to file annexures. All that court process is there. Similarly, in Parliament also, process is through motions. So no matter can be taken up, no discussion can be started without the existence of a motion. Okay. In fact, what Lakshmikant says is, no discussion on a matter of general public importance can take place except on a motion made with the consent of the presiding officer. So no discussion, no initiation of discussion can take place without a motion. So all parliament operates through motions. So what are these motions? First is a substantive motion. These are the nature of motions. What are the nature of motions? Okay. First is substantive motion. Substantive motion is an independent motion. It is a motion which is contained within itself. Okay. Substantive motion. Then you have substitute motion. In substitute motion, you alter, you change the existing motion by introducing a substitute motion. Supposing I introduced motion A, I can introduce a substitute motion B to change or alter my original motion. Okay. And last is subsidiary motion. Last is subsidiary motion. Subsidiary motion is a kind of motion which is dependent on the original motion. Supposing I had an original motion, motion A. Now I want to add some other clauses, some other annexures to the original motion. Then I will introduce a subsidiary motion, which is just additional information, additional clauses will be added using the subsidiary motion. Okay. Difference is substitute motion tries to change the original motion. Subsidiary motion just aims to add additionally to that motion. Okay. Next, what are the types of motions? What are the types of motions which can be introduced in Parliament? First is closure motion. Closure motion is to cut the debate short. Okay. Supposing we have been deliberating a bill for a few hours. You can introduce a closure motion to close the discussion on the bill. It's called a closure motion. So there are different types of closure. Simple closure. Simple closure is discussion of the bill is complete. And after discussion of the bill is complete, we are saying that let's close this discussion and vote on the bill. That is known as simple closure. Then there is closure by compartment. Now a bill has various sections to it. Section A of bill, section B of bill, section C of bill. Closure by compartment will vote on the bill by compartment by compartment. We will close discussion on the bill by compartment. Okay. Next, you have kangaroo closure. In kangaroo closure, you will go from one instead of going section A, section B, section C, you will go from section A to section G to section J to section K, section P. Kangaroo, like a kangaroo, you will hop from different sections of the bill and close those sections of the bill. That is known as kangaroo closure. And last is guillotine closure. In guillotine closure, supposing we allocated 3 hours to debate a bill. Okay. In 3 hours, we are only able to debate 30% of the bill. Then in guillotine closure, what will happen is they will say, okay, 3 hours is over, enough discussion. Whatever we have discussed, we have discussed. Now let us complete the matter. Let us complete voting. So guillotine, they will not discuss the remainder of the bill. They will say enough, discussion over. Remaining bill we will take up at once together under guillotine closure and we will vote on it. That is known as guillotine closure. So 4 types of closure motion: simple closure, closure by compartment, kangaroo closure, and guillotine closure. Next is a privilege motion. Next is a privilege motion. Privilege motion is moved by a member of the House. Who is it moved against? It is moved when they believe that a minister has committed a breach of privilege. If a minister has committed a breach of privilege, then a privilege motion is passed. Generally, what is the breach of privilege that takes place? Generally, if a minister is lying to the House, or the minister has presented a changed version of facts, a distorted version of facts. Basically, if minister is not telling the complete truth to the House, then privilege motion can be passed. Generally, how does Parliament function? You will have question hour. Question hour law, a member will ask the minister certain questions. Supposing the minister can be proven to have lied in the response to a question. So recently, privilege motion has come up a lot in the government's handling of the COVID situation. COVID situation, lot of ministers said, no, there is no issue. Everyone has oxygen. Everyone has hospital bed. So some of the members of opposition tried to pass a privilege motion against the minister, saying that no, we have facts which show that this is not true. So therefore, you must pass privilege motion against the minister. So this is why privilege motion is also in the news and important for current affairs. Privilege motion passed by a member against a minister, generally when the member has lied to the House. Next is a calling attention motion. Calling attention motion is when there is an urgent matter, when it is very important for the public, when there's an urgent matter, then calling attention motion is passed. In calling attention motion, what is the aim? Calling attention motion, they will say that this very important matter is there. What is the minister's comment about this matter? That is called calling attention motion. If I'm not wrong, recently calling attention motion was passed regarding the farmer protest. Regarding the farmer protest, they said these farmers are protesting against your law. Minister, what is your opinion on this? This comes under calling attention motion, where they will request the minister to comment on an urgent matter. On an urgent matter of public importance, they will ask the minister to comment. That is known as calling attention motion. So calling attention motion is an Indian innovation. It's an Indian innovation. This was made by the constitution, by the parliamentary procedures on its own. This is not borrowed from any other country, from any other law. Then you have adjournment motion. Adjournment motion is when there is an urgent matter of public importance. You will stop the normal business of the House. You will stop the normal agenda for the day and you will request for adjournment. Now, this is an extraordinary device. And you should know it is an extraordinary device. Why? Because this can only be initiated in Lok Sabha. If you remember, adjournment motion, no confidence motion, censure motion, these are all only possible in the Lok Sabha. So in Lok Sabha, then adjournment motion is there. Adjournment motion will stop all the business for the day. What are the criteria for initiating adjournment motion? Adjournment motion needs the support of at least 50 members. At least 50 members are needed of Lok Sabha. They need to sign adjournment motion for it to be brought. Okay. Next, adjournment motion needs to be on only one specific definite matter. Adjournment motion needs to list out a definite, factual, urgent and specific matter of recent occurrence. This is the wording. The wording for adjournment motion is needs to have definite, factual, urgent, specific matter of recent occurrence. 50 members need to sign and then adjournment motion can be introduced on these grounds. This is only possible in Lok Sabha, and adjournment motion cannot discuss privileges or it cannot discuss a matter which has already been discussed in the session. Adjournment motion cannot discuss privileges and cannot discuss a matter which has already been discussed in the session. Next is no confidence motion. No confidence motion is passed against the entire Council of Ministers. No confidence motion also does not require any reason. No reason is necessary for introduction of no confidence motion. No confidence motion can be introduced by any member. Any member of the House can introduce no confidence motion, and no confidence motion is covered under Article 75(3). So it is part of the Constitution. No confidence motion is covered under Article 75(3). It is only allowed in the Lok Sabha. And if a government fails the no confidence motion, government must resign and Lok Sabha will be dissolved. Next is censure motion. Censure motion. In censure motion, it is passed against a single individual or against a group of ministers. It is not passed against the entire council of ministers. Censure motion is passed against either one minister or a small group of ministers. So that is one big difference between censure motion and no confidence motion. Next, in censure motion, reasons also need to be stated. Reasons for the motion. In the no confidence motion, no reason needs to be stated. But in censure motion, reasons need to be stated for why the censure motion is being brought out. It also needs to state exactly which minister or group of ministers it is being brought up against. Another difference is that the ministers, the council of ministers does not need to resign if a censure motion is passed. If no confidence motion is passed, the council of ministers needs to resign. In censure motion, they do not need to resign. They can continue. But generally what happens is, if censure motion is passed, then no confidence motion is brought forward after that. Generally, that is what happens. Okay. No, censure motion does not have a minimum number of members that need to support the motion. Next type of motion is motion of thanks. In motion of thanks, what happens? Motion of thanks, the President of India is thanked for his address to Parliament. Now, when President of India addresses the Parliament for after every general election and every first session after the fiscal year. In a year, President will always address the Parliament once. Okay. And motion of thanks is passed to thank the President for his address. Okay. And generally, what happens in the President's speech? In President's speech, whatever programs, policies that the government has brought out, the President will give a summary. President will highlight what all are the achievements of the government. Next is point of order. In point of order, it is meant to bring discipline to the House. Okay. Point of order is meant to bring discipline and orderliness to the House. So what does point of order concern? It concerns the rules of the House and interpretation of the rules of the House. So supposing there is a member who is violating certain rules of the House, then point of order can be brought forward. In point of order, then they will discuss the rule that the member is violating. Okay. Generally, point of order is raised by the opposition member. Generally, point of order is raised by opposition member. What happens in point of order? Opposition member will introduce point of order and he will say government member, government minister is not following the rules of the House. So please clarify, Speaker, whether this is according to the rules of the House or no. I am raising a point of order about government minister not following the rules of the House. Okay. So basically it is meant to discipline the order and bring order in the House. This is brought about by opposition member and it is meant to control the government. One important fact for prelims, no debate is allowed. No debate is allowed on the point of order. Point of order is brought forward and then there is a verdict on the point of order. Okay. Rules of the House are established once point of order is brought, but there is no debate. Last motion is a short duration discussion. Short duration discussion. In a short duration discussion, there is no formal motion as such. In a short duration discussion, there is no formal motion as such and no voting also takes place. It is just a short duration discussion. Merely a short duration discussion. no voting takes place. Okay, and no formal motion exists. Fine. Now let's do questions. Tomorrow we'll move towards the bills, how various bills are passed, what the sessions look like. Let me post the question and then I'll answer some of these doubts. Okay, I posted the question. Okay, there's a doubt about kangaroo motion. Kangaroo closure, what happens is, like in simple closure, let's look at it by contrast, by difference. Simple closure, bill mottom discuss chestar. Bill mottom discuss chesaka, ఇది ఈ డిస్కషన్ క్లోజ్ చేద్దాము, క్లోజ్ చేసి ఓటింగ్ చేద్దామని డిసైడ్ చేస్తాం. దాన్ని సింపుల్ క్లోజర్ అంటారు. క్లోజర్ బై కంపార్ట్మెంట్ లో బిల్ మొత్తం క్లాజ్ బై క్లాజ్ డిస్కస్ చేయకుండా కంపార్ట్మెంట్ బై కంపార్ట్మెంట్ డిస్కస్ చేద్దాం. అలా డిసైడ్ చేసుకొని కంపార్ట్మెంట్ వైజ్ డిస్కస్ చేసి దాని తర్వాత క్లోజ్ చేస్తారు. క్లాజ్ బై క్లాజ్ చేసుకుంటే ఒక్కొక్క క్లాజ్ ఒక్కొక్క వర్డ్ చూసుకుంటా పోతే చాలా టైం పడుతుంది. కంపార్ట్మెంట్ బై కంపార్ట్మెంట్ చేద్దామని క్లోజర్ బై కంపార్ట్మెంట్ అంటారు దాన్ని. కాంగరూ క్లోజర్ లో ఏమవుతుందంటే ఇది ఆర్డర్ ఉండదు. సింపుల్ క్లోజర్ లో ఆర్డర్ గా క్లాజెస్ అన్ని ఎగ్జామిన్ చేసి క్లోజర్ చేస్తారు. కంపార్ట్మెంట్ లో కంపార్ట్మెంట్ బై కంపార్ట్మెంట్ చేసి క్లోజర్ చేస్తారు. కాంగరూ క్లోజర్ లో ఇలాంటి ఆర్డర్ ఏమి ఉండదు. కాంగరూ క్లోజర్ లో ఇది ఫస్ట్ క్లాజ్ నుంచి మొదలు పెట్టి మిడిల్ లో ఎక్కడో క్లాజ్ ని డిస్కస్ చేసి దాని తర్వాత లాస్ట్ 25% ని వరుసగా డిస్కస్ చేసి అలా చేయొచ్చు. కాంగరూ క్లోజర్ లో హాప్ చేస్తారు, జంప్ చేస్తారు ఒక్కొక్క సెక్షన్ నుంచి ఒక్కొక్క సెక్షన్ దాకా. అందుకే కాంగరూ క్లోజర్ అంటారు. కాంగరూ క్లోజర్ లో ఏమంటారంటే బిల్ మొత్తం డిస్కస్ చేయడం పాయింట్ లేదు, కంపార్ట్మెంట్ బై కంపార్ట్మెంట్ లో కూడా పాయింట్ లేదు. ఎందుకంటే కొన్ని కంపార్ట్మెంట్స్ ఆర్ మోర్ ఇంపార్టెంట్ దెన్ అదర్ కంపార్ట్మెంట్స్. ఓకే, ఫర్ ఎగ్జాంపుల్ ఇది ఇఫ్ ఇట్ ఈస్ డీలింగ్ విత్ గ్రీవెన్స్ రిడ్రెసల్ అనుకోవచ్చు, చాలా ఇంపార్టెంట్. ఇది లైన్ బై లైన్ చేయాలి. కానీ ఉట్టి ఫ్రేమ్ వర్క్ కానీ స్ట్రక్చర్ కానీ అది డిస్కస్ చేయాల్సిన ఎక్కువ అవసరం లేదు. దాన్ని స్కిప్ చేద్దాం. దాన్ని స్కిప్ చేసి ఈ సెక్షన్ ని డీటెయిల్ గా చేద్దాం. అలాంటి క్లోజర్ ని కాంగరూ క్లోజర్ అంటారు. అయితే కాంగరూ క్లోజర్ లో ర్యాండమ్ గా జంప్ చేస్తూ ఉంటారు వన్ ఇంపార్టెంట్ సెక్షన్ టు అనదర్. ఉట్టి ఇంపార్టెంట్ క్లాసెస్ ని డిస్కస్ చేసి మిగతా సెక్షన్ ని డిస్కస్ చేయకుండా ఉండడం ని కాంగరూ క్లోజర్ అంటారు. ఓకే, హోల్డ్స్ ఆఫీస్ during the pleasure of president. What does it mean? It means that if the president decides to take away your office, president can take it away. So governor holds office during pleasure of president, meaning if today governor decides if today president decides I want to change the governor, president can change the governor. Okay, so that is holding office during the pleasure of president. But what about judge of Supreme Court? Judge of Supreme Court does not hold office during pleasure of president. Even though president has appointed the judge of Supreme Court, only the parliament through impeachment motion, removal motion can get rid of the judge. Okay, judge has independence. For point of order, yes, speaker is deciding authority because speaker is the guardian of the rules and order of the parliament. So answer is D for Delhi. Which okay, not enough of you have gotten it right. So all India services operate on tenure system, which is correct. What is tenure system? Tenure system means that officers are generally allocated to a cadre. A cadre system is there, right? Where you are allotted Jammu Kashmir cadre or Assam cadre, Telangana cadre, right? After that, you go to the center on a fixed tenure. If you go to the center, if you're serving as joint secretary of Ministry of Defense, okay, then that is that is what is known as a deputation post. You are going only for fixed tenure. You will go for a period to central government and you'll come back to the state. This is known as tenure system. Okay, this is known as tenure system. And obviously option B is correct. Rajya Sabha has the power under Article 312. Then salaries and pensions of officers are met by the states. This is also correct. Okay, all India services, the salaries and pensions are provided by the state because they are first officers of the state. D is incorrect. D is incorrect because by definition, all India services, both center and state have control. It is not only the center. So appointment happens by DOPT. Appointment happens by DOPT, but the control over postings, control over service, that both center as well as states have. Okay, and UPSC will confuse you with options like this. I've seen it in the past as well. Those of you who are answering B, read the question very carefully. Okay, so answer for this question is A. A for Ahmedabad. What is the reason for this? Now let's look at defection, anti-defection law. You're all aware. If a member votes against direction of the whip, he will be disqualified under anti-defection law. If a nominated member, okay, if he joins any party after the expiry of 6 months, then he will get disqualified. And for an independent member, if he joins any political party after being elected, he will be disqualified. Right? So, first statement is right, third statement is wrong. In second statement, they basically played with the words where they say that if he joins any independent member, what do we know based on anti-defection law? Independent member is disqualified if he joins any political party immediately after election. Okay. So if he is disqualified immediately after election, or if he joins a party after 6 months, after he joins after 1 year, if he joins after 2 years, anytime if he joins, he'll get disqualified only. So which is why statement 2 is correct. Statement 2, they're basically playing with some of the words to make it confusing. Statement 2, independent member of the House may be disqualified if he joins any political party after the expiry of 6 months. It is true. If he joins after 6 months any political party, he will be disqualified. So which is why, yeah, if the statement had only, if it was independent member may be disqualified if he joins any political party, only if he joins after expiry of 6 months, then the statement is wrong. But if he joins after 6 months also, he'll be disqualified. If he joins after 1 month, if he joins after 2 months, 3 months, 4 months, 6 months, 1 year, 2 year, anything, he will be disqualified, independent member. So statement 2 is also correct. Nominated member has 6 months to join a political party. After 6 months, he cannot change his political party. Next, last question for today. So answer for this question is A. A for Ahmedabad. Most of you have gotten it correct. So I'll just run through this quickly. So what are the qualifications for someone to get appointed to be president? Minimum age should be 35 years, should be citizen of India, should be qualified to become member of Lok Sabha, and he should not hold any office of profit under union or state government. Only these 4 conditions are there. So statement 1 is correct. How is president elected? President is elected by the elected members of the Lok Sabha as well Rajya Sabha, as well as the states, the state legislative assembly. Right? So if there is a Rajya Sabha member elected from Union Territory, meaning Rajya Sabha member elected from Delhi or from Pondicherry, they can also vote because they are elected members. Only nominated members cannot vote. Elected members can vote. Next, decision of Supreme Court is final regarding disputes, which is correct. No, nothing else can interfere in this. An elected member of parliament cannot abstain from voting. Yes, he can abstain. He can abstain. Why? Because whip is not applicable for president election, vice president election, for Rajya Sabha election. Again and again, I'm mentioning this. Presidential whip, this whip, voting whip, is not applicable for presidential election. So in which case, if a person wants to abstain, he can abstain. If he wants to vote for someone else, he can vote for someone else. You cannot be forced to vote for someone under presidential elections. We meet again tomorrow. And thanks everyone. Tomorrow we'll try and, hopefully we can complete quickly. Then I'll try and do more questions. But yeah, I think at least what we're discussing today is quite important. So it's okay to give time. Yeah, we'll meet again tomorrow.